Welcome to Advocacy Exchange, Navigating Injury Texas Law.
Hey everyone, welcome back to an all-new episode of Advocacy Exchange, Navigating Texas Injury Law with Paul Littleton. I am your host, Mike Leon. You know, Paul is the Director of Business Development and Operations over at the Littleton Law Firm, where he helps guide strategy, client communication, and case management all across the firm. Today's episode, we're going to be talking about recorded statements, why they can cause problems in injury cases, and what people should understand before ever agreeing to one. Paul, it's good to see you as always. You know, let me ask you about what happens after an accident. I'm sure people, they get contacted quickly by these insurance companies. We're going to get into that in a second. The companies are asking for a recorded statement, but why did the request happen so early in the process?
Well, there's a few reasons. Most of them are pretty sound. I'm not going to make the insurance companies sound like they're doing anything, illegitimate or conspicuous. But the idea behind getting these statements early is because that's going to be the freshest account of what happened. A lot of times, people's mind will, if they don't know something, kind of bridge gaps that they may not understand or know. And so the recorded statements are designed to trap that so that they can get the best or most accurate version of the story. But there are a lot of potholes in that people can fall through. And that is what the insurance company is hoping to get, because if they're able to disprove a claim, even if it's a small fact in an entire statement, then it gives them leverage to overturn their decision of liability or not.
So is that the only reason the insurance adjuster is doing this, or at least trying to accomplish through this recorded statement? Like, is there something else that they're trying to accomplish with getting the statements down?
Oh yeah, well, they're trying to pin you down. See, in Texas, you have comparative negligence as well as liability or denial liability, right? So they can either accept fault, not accept fault, or they can place you partially at fault. And in Texas, you have to be 51%, negligent in order to be considered at fault for a particular claim and a tort claim. So the idea here is that the insurance company gives you a statement and peppers you with questions, sometimes that sound very innocent in nature and would happen in normal conversation. But when you actually think about them, they can pin you down to kind of put yourself, at risk of having some contributory negligence to the case. Like for example, an insurance company may ask you, did you see my insured's vehicle prior to the collision? And that question can vary, because if you did, well, then you had plenty of time to avoid the accident, which is, something that you should have done under the law. But you could also mean that if you didn't, you were not being aware of your surroundings, which is also a requirement of the law, to be observant of your surroundings. And so they will use pivot questions like that to kind of pinpoint where you are in the circumstance and what they're able to kind of pin on you on that with your own words, your own answer to the question.
So let me ask you, because you mentioned about, did you see the car, small details. Expand a little bit about like how to avoid giving those small details or those casual comments in a recorded statement, because it's ultimately going to shape how the claim is evaluated later on, right?
Oh, definitely. So the best way to do this is to use common sense. And I know common sense is not common. Our brains just kind of ride over on autopilot with things when we talk about what happened or we narrate a story that occurred. So the idea here is that if you're moving, if you're waiting at the light and some guy rear ends you, just as an example, and then the adjuster asks you, did you see our insured's vehicle prior to the collision? The answer is no, because common sense would tell you that anyone waiting at a light would be focused on the vehicles ahead of them. Anyone going through an intersection would be focused in the direction that they were traveling. Things like that, right? So you can answer honestly and say, no, I wasn't. I was actually paying attention to the cars in front of me, which makes more sense. And so if that was ever presented to a jury, the jury would align themselves with what makes the most common sense, what a prudent person would do, which is actually an element of, tort law and the civil law as it is. So a prudent person would be any normal person, what would be the common response to a situation. And most people will look ahead, in those examples rather than look behind them.
Right. Paul, is it difficult to fix a recorded statement once it's been given, even if somebody does realize that maybe it didn't fully reflect what they were trying to articulate? Is it easy to fix?
Yes, absolutely. It can be difficult. Typically, if the recorded statement is such that maybe the client did the statement prior to representation, or allowed the adjuster to kind of lead with the questions rather than answer them under the guise of common sense, what would have to happen is either the adjuster would have to retake the statement under a special investigation, or we would have to litigate the claim, file a lawsuit, and then at that point, depositions would occur, and the depositions would kind of supersede the statement that was provided. But the only problem in that is it does have a chink in that armor, in the fact that they could present both stories or both versions to a jury, and the jury may turn around and look as the first version being the most accurate because it was done quickly after the incident versus later on when litigation would occur.
So, perfect follow up. I'm assuming then timing does play a role when you give that recorded statement, or does it help? Does it help? Does it hurt with respect to the injury claim?
Timing does play a role, and we always encourage our so for us, what we typically do is we will not allow the recorded statements to occur right after the accident. If there is a police report or some sort of investigative tool that we could use that would be released to the public eventually, we will wait for that to occur before we allow our clients to take statements. And we always prep our clients when we're doing that as well, because to give you an example, there's a lot of things that are on police reports that are sometimes wrong. So if a client goes by an act, what they remember or what they know, it may be different from the police report. And if that occurs, well, then we need to make sure that we've properly prepared for that in terms of what we can prove, the evidence. So the timing does matter. Yes, it does need to be pretty soon after the accident. Usually police reports are ready within 10 days, give or take, of the accident. So that's the time frame that we're going to look at for those statements. But giving statements that maybe don't have a police report, we definitely try to get our client to explain it to us, print out, a copy or aerial photo of the accident so they can walk us through it so that it makes sense and that we can kind of properly prepare accordingly. But we're looking at getting those statements done within that kind of 10-day mark for the betterment of both sides.
Yeah. When you compare cases that you've worked at or seen at the firm, and there's a recorded statement involved, and it becomes a major issue versus cases where there wasn't a recorded statement, like what are some of the differences that kind of tend to show up in how the early conversations were handled?
So typically the insurance carrier is going to require, a few different elements before they render a liability decision. You're either going to have a recorded statement or a police report, one of those two, before they move forward. So cases with recorded statements have a little bit more value, I believe, in terms of the claim, because the bodily injury adjusters will commonly refer back to the recorded statements to kind of get a picture about what the client actually felt, if there were immediate symptoms that occurred or they felt, at the time of the collision, rather than maybe a few days later or a week later, like some claims. Claims where there's an immediate treatment, hospital, urgent care, those claims are evaluated higher. So when they have the recorded statements, the adjusters from the bodily injury standpoint will review them just to kind of give a measure or guide on that. Those claims that don't have a recorded statement will traditionally be valued less. And that's just primarily because they don't have anything to go off of. And if they don't have anything to go off of, they're not going to go ahead and ask questions. And if your attorney's office is not providing that insight for them, then those factors never get into the evaluation. And it's just not, their scale, their authority is going to be a lot less than it would be if they did have that.
Right. Paul, let me ask you, what misunderstandings have you seen people have about, like, they think that they're under obligation to give a recorded statement after an accident, but I'm sure there's misunderstandings about that. You don't have to give the statement, obviously.
You don't have to to your insurance carrier, you do, right? There's a contractual obligation between your policy and you as their insured. And so when they request you to provide a recorded statement or maybe even a written statement, then those statements are going to be something that you contractually have to provide them if you want them to defend the claim, if you want them to actually provide insurance for your circumstance, which is always in your best interest. Even if it's something simple, even if the other side did accept fault and your insurance carrier wants a recorded statement, it's always best to give that, because anything later, maybe they put this claim accidentally as your fault when it wasn't your fault, and you give a statement, they can always refer back and clean it up very easily. So that's that. But as far as the third party is concerned, or the liability carrier, no, you do not have to give a recorded statement at all. A lot of attorneys' offices don't provide them. A lot of attorneys' offices only provide written statements, so that it can be clean cut and a lot less to interpretation. However, we have found that those attorneys' offices or those people that don't actually provide that information almost hurt their claim, because the insurance company is still under an obligation to investigate. And if there's no police report, then all they've got is their insured's version of the story. And so when you only got one side of the story, well, that's the only thing left to believe, even if your clients make perfect sense, in retrospect. So depending on the circumstances, largely we do encourage those to give statements if they're requested.
Yeah. Paul, for someone who's listening to this and they've been injured and they're a little unsure of how to handle that early contact phase from the insurance company, you explained a lot of it here, but what should they understand about protecting the integrity of their claim from the very onset?
Well, in terms of the integrity of their claim, representing the truth as best as you know it. And first of all, you have to understand it is okay for you, as a client or a person involved in an accident, to say you don't know something. It is better for you to say you don't know than to answer the question the best that you see fit, or reason some sort of answer that makes more sense. If you didn't see the person, you weren't looking for the person, maybe you think this occurred, but maybe you don't know it occurred. Whatever the truth is, you just need to lay it out there. Don't say something that you don't know. Make sure you say you think if you think rather than because those things allow for common sense, or in what most people provide, to play out, especially in front of a jury if you're ever having to bring that up as evidence. Because to say I thought that the light was yellow, or I didn't see the 18-wheeler, I didn't hear the car because my stereo was up, or whatever it may be, are all reasonable explanations, and there's nothing in the law that prevents that or thinks that is some sort of contributory negligence factor. So when you're talking about the integrity of the claim, always go in with the truth first. It is okay for you to say that you don't know, and it is definitely okay for you to say, I don't feel comfortable answering that right now. You are not obligated to provide an answer if it's not comfortable. And to give you an example, in a recorded statement, a lot of times they'll talk about the injuries. You can only claim what you know. So you can say my neck hurts or my back hurts, right? But to say that it's a bilateral pain that radiates through, your lower extremities, and be specific, those things, if you're not a trained medical professional, you don't need to be saying you don't know what the doctors are going to diagnose you with. If they try to get you to state anything about your prognosis or your future medical, you don't know. You're not a physician. You're at the onset of this thing. All you know is that it hurts and that you're seeking treatment for it, or will. If you're not feeling pain right now and the insurance company gets you on the phone for a recorded statement, maintain your truth. At this point, I'm okay. I'm managing everything on myself, but I don't know if I'll need to go to the doctor future because I just don't know what's going to happen. That is an honest to God truth, and that's all we're asking you to say.
Yeah, it's great advice as always, Paul. Can't thank you enough for the time and the insights. I appreciate it.
No problem.
That's it for today's episode of Advocacy Exchange, navigating Texas injury law. I'm going to sound like the billboards, but if you've been injured in an accident, you've got questions about how early in conversations with insurance companies can affect your case, do me a favor right now, visit the team over at Littleton Law Firm by going to littletonlawfirm.com to learn more and connect with Paul and the guys over there. And thanks again for listening, but don't forget to like, subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.